Supreme Court, no time limit on monetary recovery in copyright cases. The U.S. Supreme Court has ruled in favor of Sherman Neely, a record producer who sued Warner Music for copyright infringement over a 2008 song by rapper Flo Rida, finding there is no time limit on monetary recovery in copyright cases filed before the statute of limitations has expired. As the decision notes, under the Copyright Act, a plaintiff must file suit within 3 years after the claim accrued. 17 U.S.C. Section 507b. On one understanding of that limitations provision, a copyright claim accrues when an infringing act occurs. But under an alternative view, the so-called discovery rule, a claim accrues when the plaintiff discovers, or with due diligence should have discovered, the infringing act, EBID, and for. That rule enables a diligent plaintiff to raise claims about even very old infringements if he discovered them within the 3 years prior to suit. In 1983, Neely and Tony Butler formed Music Specialist Inc., a company that recorded and released one album and several singles, including the works at issue in this case. A few years later, the collaboration dissolved, and Neely went to prison for drug-related offenses, serving from 1989 to 2008 and 2012 to 2015. Butler, unbeknownst to Neely, entered into an agreement with Warner Chappell Music Inc. to license works from the Music Specialist catalog. In 2018, after he got out of prison for the second time, Neely sued Warner Chappell for copyright infringement, alleging that he held the copyrights to Music Specialist songs. Neely alleged that his claims were timely because he didn't learn of Warner Chappell's infringing conduct until 2016, just after he got out of prison and less than 3 years before he sued. A district court applied the discovery rule discussed above, but ruled that even if Neely could sue for infringements going back 10 years, he could recover damages or profits for only those occurring in the last 3. The 11th Circuit disagreed and reversed. Justice Kagan, writing for the court, noted that U.S. copyright law states that an infringer is liable either for statutory damages or for the owner's actual damages and the infringer's profits. However, there is no time limit on monetary recovery, so a copyright owner possessing a timely claim for infringement is entitled to damages, no matter when the infringement occurred. This, said the court, the district court limiting damages to 3 years, is essentially self-defeating. With one hand, that court recognizes a discovery rule, thus enabling some copyright owners to sue for infringing acts occurring more than 3 years earlier. And with the other hand, the court takes away the value in what it has conferred by preventing the recovery of damages for those older infringements. 3 of the justices dissented, suggesting that the discovery rule itself is invalid. The dissenters acknowledged that the discovery rule wasn't before the court because it wasn't challenged in lower courts, but said they would have dismissed the case and awaited another case in which the discovery rule was at issue. That soon enough suggests that at least the dissenting justices would welcome an appeal in which the discovery rule was directly at issue and that they'll invalidate if given the opportunity. Need to defend your copyrights? Book an appointment with us at www.eonlaw.com. Eon Law, unleashing genius.